Good evening. Today's date is Wednesday, December 20th. The time now is 6:05 p.m. This is a special meeting of the Board of Education. Today, we're going to, in part, have a presentation regarding the legal duties and responsibilities of the Board of Education. The first item on the agenda is public comment. Public comment is limited to the agenda item only. And we have one person signed up for public comment, and that is Orlando Strong. You have 2 minutes.
Good evening, you guys. I'm standing up here today. I know it says stay on the agenda, and I'm glad it does because it's one of my topics is roles for you guys. I was here last meeting, and I'm gonna be honest with you guys, as a public member, that broke my heart. It really did. It really did, to the point I had to come to the city council meeting and talk about it to them. I need to know, as a PAC member and a community leader, what are the roles? And the only reason why I'm asking, because when I ask what the roles is, everybody's always bickering. I need to know because I'm also a PAC leader for classical studies. I have students that's asking me, I have parents that ask me, what do the board members do? What do they talk about at the meetings? I didn't even want to bring my parents here today because I didn't know what was capable of happening. I'm willing to sit down and hear what your roles are besides what I was hearing in the last meeting. Even the disrespect towards, the superintendent. I am going to bring that up because as board members, one of your roles is, regardless if you don't like what she's doing or whatever she says, you still have to have some type of respect for her. And no one at this podium showed any respect. None. At all. Down to half of you guys are older than me. And it looked disgusting. It broke my heart, again, literally. I have 2 kids here that I took out of the public school system because of what was going on. So I don't understand. I don't need the mic because I'm very loud. I got a bunch of kids. I don't need the mic.
It's for YouTube purposes.
Okay.
Why did it stop? Sometimes that might go.
Online still hears her.
They can still hear it, so you can continue if you raise your hand.
Yeah, I can. Okay. I just want to, as a superintendent, I want to know her role. I want to know everybody's role on who they report to, who the PAC presidents have to report to when stuff happens and we have questions, because I can't come to you guys if you guys can't work together. So, I feel like you guys got to come to some type of agreement when it comes to us as leaders in the community.
Thank you, Ms. Strong.
I have a question.
The next item on the agenda is presentation and discussion of duties and legal responsibilities of board members by Berchman Moses. This item includes, but is not limited to, the board's role in the community, the board's function, the superintendent of schools function, the role of the board attorney, collective bargaining and employee discipline. It'll touch on the Freedom of Information Act, Robert's Rules of Order, general do's and don'ts of board members, and as well have a Q&A session. This will be done by Attorney Floyd Dugas of Berchman Moses.
Thank you. Are you guys going to be able to hear me?
Yes.
Thank you and welcome to the new board members. I look forward to working with you all. My name is Floyd Dugas, as indicated. I'm a senior partner at the law firm Berchman Moses. A very big part of our practice is representing school districts. We represent approximately 30 districts throughout the state in various capacities. And that ranges from some of the smallest districts in the state up to and including you guys, biggest district in the state. My presentation, well, first of all, let me first apologize. I'm fighting a cold, so I'm going to try to keep my voice going for about an hour here. But my focus is initially and primarily going to be on the law. And I know that may sound a little boring or intimidating, but basically what I'd like to do is help explain some of the key laws that control what you folks do, to give you a little bit of context as you do what you do, so it'll help you understand why you do certain things and you need to follow various others. So whenever I do this presentation, I always, believe it or not, start with, where it really all begins, and that's in the Connecticut Constitution. In the Connecticut Constitution, Article 8, Section 1, it guarantees the children of the state of Connecticut a free public education. So that's where it starts. So it sort of raises the question, well, if that's the obligation that's imposed in the state constitution, and it's imposed on the state of Connecticut in the Constitution, why is it your problem? How does that get to you folks? And the answer has to do with the fact that what the General Assembly has done, 100 plus years ago, delegate that responsibility to local boards of education and regional boards of ed where those exist. So basically, the Constitution says kids are entitled to a free education. The state of Connecticut has that responsibility, and they've now punted and delegated that responsibility to you folks. And so that's why and where this all comes about. Now, so that kind of raises a question that sometimes comes up, and that is, well, are you agents of the state of Connecticut, or are you agents of Bridgeport? And the answer is really both, but first and foremost, you're agents of the state of Connecticut. Okay, you have to comply with the laws of Bridgeport. You obviously represent the children of this great city, but you're first and foremost an agent of the state and carrying out the state's duties. So that's basically the broad strokes. Now, there are a few statutes I want to refer to because they come up all the time and they help to understand what your role is and how it works. And the first is General Statutes 10-220, and this is in the materials. And what you'll see is this is where the state primarily delegates responsibility to you to do a bunch of things, but two things in particular. One is to maintain good public and secondary schools, and the other is to implement the educational interests of the state. Okay, very broad concepts, and there are other things, but that's the primary delegation of responsibility from the state down to you folks. The second is 10-221. You'll hear me talk a lot about the roles and responsibilities of the board, you guys, as compared to the superintendent. Well, this is really where your primary duties and responsibilities come from. And that primary role and responsibility is to develop policy management of the school system. Develop policy, okay, primary job. Another very important statute is 10-222. That statute requires you to prepare a budget to the city. The city will ultimately make an allocation to you. Once it makes that allocation, it cannot control how that money is spent. That's up to you guys to decide how that money is spent. And what we say is, in terms of the obligation I mentioned before about maintaining good public and secondary schools, as well as maintaining the educational interests of the states, it's really how you do it, is the budget, okay? It would be remiss of me if I didn't point one thing out, and that is there's another statute, 7-349. And what it basically says is you guys are responsible if you don't stick to the budget, okay? Now, if there's, some minor overage or something, that doesn't really concern people, but you need to understand that is a theoretical responsibility for you. So that means you ought to make sure that the district is within its budget. I know as long as Marlene Siegel's around, that's not a problem. But you guys need to make sure, and you should certainly ask and make sure that's things are on track. There's another statute that I refer to here, 10-240. What some folks don't understand is that the city actually owns all the school buildings. Okay?
Repeat that, please.
Yes, ma'am. The city owns all the school buildings. Okay? But they are given to you to use in your discretion while they're being used for educational purposes. So in theory, you guys are the ones who decide who can come in your buildings, how they get used. And at the end of a life cycle of a building or a piece of property, if it's no longer used for educational purposes, you give it back to the city. But during that time period, it's in your control and use. Now, I recognize schools can be effectively like a community center. There's rec programs and the city gives you funding. So there's a lot of cooperation that tends to happen. But they're yours to use and control, but the city ultimately owns them. And one other point, there's a statute 10-241. And that statute gives certain authority to the quote unquote school district. The school district technically is, in this case, the boundaries of the city of Bridgeport. And it's the city that has those duties and responsibilities. I mention that only because we tend to use the Board of Education, the Bridgeport Public Schools, the Bridgeport School District. We use those interchangeably. Lots of folks do, even lawyers do. We slip into that, but I just wanted to draw that distinction. So those are some of the laws. I mean, I could literally line up the laws and they would tower over me, all the laws. There's all kinds of federal laws that are controlled. Fortunately, you don't have to know those. I don't even necessarily have to know most of them. There's just a lot of federal laws, there's state laws, there's the charter in Bridgeport, and then there's your bylaws. And your bylaws are basically, they're sort of like a law. They're the rules that govern how you conduct yourselves. Okay? So that's yet another layer. And if nothing else, I would strongly encourage all of you, particularly you new folks, to become familiar with the bylaws, because that's how things are done, and you should comply with that. And so that's something you should look at. I would draw your attention to a couple of things. One of the bylaws, and you'll see in the materials I have orange paper separating. One of the bylaws I put in here, behind the separator, is 9110, and that is the code of conduct board members. And I would encourage you to take a look at that. You'll see, among other things, it lays out 5 specific rules there, including conducting yourself in a fair and impartial manner, refrain from interfering with the implementation of board policy decisions by the administration, and to refrain from interfering with the duty of school district officials.
To this point of personal privilege, we were rearranging as a board member just walked in, so let the record reflect Vice Chair Atisha Cashmere is present. And actually, let's just go through roll call for attendance, but the secretary is not here. So I'll take attendance. And so we're going to just briefly pause so that way we can have that for our record. Just going to do a quick roll call. So Sahiba Bain, myself, Christine Baptiste Perez, present. Howard Zenneman. He's showing up as virtual. I'll come back. Ms. Casimir is here in person.
Present.
Mr. Medina? Not here.
I'm present.
Oh, I see you now. Mr. Medina is virtual. Ms.
Thank
Perez?
you.
Okay. Ms. Perez is not here. Mr. Sokolovic?
Present.
Mr. Traber?
Present.
Mr. Woodson?
Present.
Okay. So I apologize, Mr. Dugas, if you could just go back briefly to, and which particular section, Ms. Bain?
Bylaws.
We're at the section, I believe, section 4 on page 3 regarding section 5, page 3, the bylaws of the Board of Ed, and you had just gotten started in that section. Could you start back?
Sure,
Thank
sure. So what I was basically saying is you can consider that sort of another layer of laws. And what I was trying to say is, there's all these laws I'm talking about and they're out there. But one of the most important ones for you folks to familiarize yourself with are the bylaws, because that governs how you run your meetings and how you conduct a lot of the business in the school district. So very important. I did mention specifically the code of conduct is one of them I always like to point out. That's 9110. I've got that behind the first orange separator, which is where I have some backup materials for you, and encourage you to take a look at that. There's also one that's 9120 talks about conflict of interest. That's also included in the materials, and just simply that one points out that it is, and there's actually a statute on this in Connecticut that prohibits you from being employed in Bridgeport Public Schools in any capacity. Teacher, coach, referee, parent, you name it, you cannot be employed for compensation in the school district. And then the other thing I've included here is a section from the City of Bridgeport Code of Conduct, and that's actually the Code of Ethics. That is also in the materials behind what would be the next orange divider. I would just point out a couple of provisions in here. On the second page, 2 of 7 of that, if you have it in front of you, but if not, general prohibitions are that you can't have any any interest, financial or otherwise, in any district business. If you have a business of some kind, you can't do business with the school system. You cannot solicit any gifts or accept any gifts to influence you in how you do your job, or to try to influence somebody who's in the school system. You can't disclose confidential information that you will come into play with. You can't use school district property for your own personal use. I one time had a case where it was a town, similar rule, and somebody decided they use a police radar to see how fast their kid's fastball was. I mean, that's the sort of thing you can't do. You can't use school district property. So I would encourage you, and another one, fair and equal treatment. Official or school employee shall use his or her position to secure any special treatment for themselves or family members, other than what's available to the general public. So take a look at that, because you are bound by the city charter. In theory, somebody could file an ethics complaint against you, and that's just a real headache. You want to familiarize yourself with that. Other key law that I include under this section, and I'm going to come back to in more detail, is the Freedom of Information Act. I see you guys have a copy of a book that's been put out on that, and I'm going to go over that in a little bit of detail today. I've also attached in the materials an outline that I have done and presentations on the Freedom of Information Act. It's a little bit of a deeper dive I'll get into tonight. Not as much of a dive as the book you have.
Take a mile.
Principles that you should know and be aware of. Okay. All right. I want to turn to individual board members, your qualifications, authority. First of all, in order to be a board member, you have to be an elector of the city of Bridgeport, which basically means you have to live here. You have to be at least 18 years of age. I'm assuming everybody meets that requirement. And I mentioned the thing about not being able to work for the school system. Now I want to talk a little bit about legal exposure. One of the things they don't tell you, or maybe they do, but a lot of places you never hear about when you raise your hand to run for the Board of Ed is, in theory, as a member of the board, you could get sued, okay? And what I'm here to say is it's just sort of comes with the territory. It's not something you really need to worry about. If you find someday a sheriff at your door serving, you know, don't worry about it. Just give it to the superintendent. She'll get it to the city attorney's office or us, and we'll handle it. But a few things. One of which is there's something known as governmental immunity. For many acts, you are protected under the law as long as you are acting, you know, in good faith. And there's a specific statute that requires the board and the Bridgeport Public Schools to indemnify you. In other words, provide an attorney, cover any damages that may come from a lawsuit. So that's a second layer of protection you have. And for that to apply, again, that comes down to your acting in good faith. So if you're acting what they refer to as willfully, or maliciously, or intentional to harm somebody, the indemnification doesn't apply and you could have some exposure. So if somebody were, you know, just out to get somebody, right, and that were proven and there's a lawsuit and you say, you know, board, you've got to indemnify me. If it's ultimately found that your actions were willful and intentional, then you may not have the protection provided by the statute. There's another statute, 10236, that allows the city and the Board of Education to provide for insurance. The city is self-insured for some things and not some others. There's a very good and deep city attorney's office here, in addition to the insurance, so you have a lot of protection there. One thing I will mention, in addition to what I've already said about if you're acting in bad faith, trying to go after somebody or doing something, trying to harm somebody, another thing that you cannot be indemnified for is if you slander somebody. Okay, you defame them. So you say, you know, that Dugas guy is a cheat and a steal, a cheat and a philanderer or whatever, and it's not true. Of course, it's not true. Then and you get sued, and you know and it's found that you did in fact know that what you said wasn't truthful. You cannot be indemnified. So just be careful with that. You know, basic rule of thumb: as long as you act in good faith, treat people the way you want to be treated, you're not going to have a problem. It's only when you really go off the rails and are trying to hurt somebody and do hurt them that you really have anything to worry about. I'll say this probably a couple of times, but let me just say it again. As board members, you only have authority, power, when you are sitting in a meeting like this. That's been duly noticed, and you act and you vote together. If you go off and you're on your own, you know, you don't have superpowers now to go into a school and tell the principal what to do or demand to see somebody's personnel file that you're not otherwise not entitled to. Only when you're acting as a group. So just understand that role. So I'm going to shift a little bit and talk about board function, and then I'm going to get into the superintendent's role. This is a very important distinction. We talk about this all the time. If you bring CABE down, they're really going to talk about this a lot. And it's important for every board to understand this. And I can tell you, I've been doing this for 37 years. Boards that follow these rules operate the best. Okay? So what is your role? I talked about, well, first of all, your role is to set goals for the district, right? What do you want to achieve? and then to formulate policy aimed at achieving those roles. Okay. You should then evaluate how we're doing towards those goals, and where necessary, then amend your policies to try to affect those goals you're trying to achieve. Once you've developed the policies, it is then up to the superintendent and the administration to administer those policies. It is not your job to administer them, your job to set the policies, then the administration's role to implement them. I talked previously about your role in the budget process, and that's obviously a very, very important role, and one you'll spend, I'm sure, a lot of hours in the near future, if you're not already started, in terms of developing the budget, and that really goes a long way to carrying out many of your responsibilities. Your role is to hire and evaluate the superintendent of schools. It is often said that you have one employee, and that is the superintendent. And then everybody else reports to the superintendent through the chain of command, but that is your one employee who you have supervision over. You don't supervise the principals, okay, or the teachers or the custodians or whomever. Under the law, you have the duty for bargaining with your unions. Now, Bridgeport is a little unusual. You've got the teachers union, you have the administrators union, but the custodians, the paraprofessionals, secretaries are all under a city contract, and the city negotiates for those folks. A little unusual in most situations, they would fall under the Board of Education, but it's primarily the teachers and the administrators. And typically what will happen is there will be a liaison who's appointed in those negotiations. Typically it would be the business manager. It would be myself. It would be, a member of the Board of Education, somebody from the administration, sometimes a superintendent, sometimes an assistant, something of that nature. But you would have a liaison on the board that would report back to you guys in terms of what's going on. And then importantly, the contract isn't binding until it comes back to you and you vote on it. And that's the key role you play. You play a role in things like student expulsions. And remind me, do you guys use hearing officers, or you do them yourselves? I can't remember. Use hearing officers? Yeah. Under the law, you have the option to either hear them yourself or use hearing officers. I can't tell you enough how it's a good thing to use hearing officers. You guys are out enough as it is. The hearing officers know what they're doing. They know the law, and it's a good way to ensure compliance. School accommodations, things come up like a residency issue. Does somebody have a right to go to school here? Bus stop, do they have a right to the bus stop? Is the bus stop in an unsafe place? Those sorts of issues could theoretically come before you guys. Teacher terminations. Now, this is a very unique sort of thing. It's not governed by the labor contracts, which you would normally see. They're governed by a statute, the Teacher Tenure Act. And what that says is basically, first of all, we separate it into tenured and non-tenured. And in a non-tenured situation, we call it non-renewing somebody. If they're not cutting it, the way the process should work, and it does, what I've seen here very well, is we talk to the individual and say, yeah, it's not happening for you. Maybe you want to move on, and we counsel them out. If they fight it, they're entitled to, in some cases, a hearing before you guys. But tenured teachers are different. They are absolutely entitled to a hearing. We call it a due process hearing. It's one of the most high burdens in terms of process that any employee could get. And the way that process works is, under the law, the superintendent initiates it. And we've had some of these in recent years here. The teacher has a right to request a hearing. they can either do it before you or before an independent hearing officer. Usually they pick an independent hearing officer, but if it's an independent hearing officer, what happens is they will have a hearings, they'll make findings, and they'll make a recommendation, and then that comes to you, and you ultimately, you have to accept their findings of fact, but you don't have to accept their recommendation. So if somebody did something and the hearing officer says, yeah, it was bad, but I don't think they should be fired over it, you can say, yes, we think they should be fired. And when that happens, we say that you're sitting, the technical term is in a quasi-judicial capacity. What that really means is you're acting like a judge, okay? And what the law says is a teacher in that situation, their rights include the ability to come before you without your having made up your mind ahead of time. If you have, then they have a right to throw the case out. And what I'm talking about is after 6 months of hearings, $50,000 or so in legal fees, the whole thing gets thrown out and we have to start again. If when that comes to you, one or more of you have made up your mind and not recused yourself. So what does that really mean? If we have a problem with a teacher, it starts with the superintendent, she'll consult with us, and you won't be provided information at that point. Now, you may want that information, right? Teacher may have been arrested for something. And you're going to want to know about that. Or if it's in, your neighborhood, people are going to be asking you about it. But we can't give you that information because if you get too much information, the law will basically say you've made up your mind already, or it's impossible that you didn't make up your mind. Or what happens a lot is somebody says, that teacher's got to go. And then somebody else hears it, it's reported, and then if you don't recuse yourself in that situation, we could throw the whole thing out. So if that ever happens and you find that the superintendent is not giving you all this information, it's not that she doesn't want to share it, it's that the law really prohibits it, and it's about protecting the teacher's rights. Okay. My next section is chain of command. Again, very basic concept, but one that is so critically important for this system to work right. And basically, any complaints that you receive, information you receive, should be passed on. And we always start at the lowest level. So somebody's got a problem with their teacher, refer them back to the teacher. They're not getting anywhere, refer them to the principal. If the problem's with a principal or it's still not effective, then you refer it to the superintendent and her staff will take care of it. You should not get involved in trying to fix the problem. First of all, for the employee, it's for the reasons I just talked about. If it's a child, then the rules and the laws regarding the privacy of children come into play, and that's another reason why we do that. And it's just, it's whether you look at national school board information, CABE information, I can't emphasize enough how important it is to follow the chain of command, not just because we want to say to somebody, mind your own business, but because that's how things work properly. Your principals get paid good money, let them do their job. Superintendent gets paid good money, let her do her job, rather than get involved, and it creates potential legal issues. You will hear the term, if you haven't heard it already, and I know you veterans have heard it plenty of time, FERPA. Okay, the Family Education Right to Privacy Act. It's a federal law that basically says, other than somebody who absolutely must know, information about a child is to be kept confidential and private. Child's grades, whether the child is in trouble, whether the child has a disability, the child has a health condition, those things need to be kept private. So let me give you an example of how this could come out. Parent says to you, there's a new kid just moved into the neighborhood, he's in the school. this kid is a bully, he's picking on kids, he's got ADHD, he's got, whatever. And somebody comes up here and says that, well, we've just violated that federal law FERPA. Okay. And so that's why those things need to be handled by the staff. Other than saying to the superintendent or the principal, I got a phone call, this kid's a problem. Chances are the superintendent's already heard about it, but follow the chain of command. And so we can avoid, tripping up on any of those kinds of laws. Okay. So let me now shift to the superintendent. Again, we have a statute, 10-157. And it says some things that, can be surprising to some folks. One of which is it refers to the superintendent as the chief executive officer of the board. Okay, I'm still not sure exactly what that means, but, that's in the statute, but obviously she's an integral part of the board. And, and it says that the superintendent is the one with responsibility for the day-to-day supervision and oversight of the schools, her and her staff and the folks that report to her. And is responsible for supervising all staff. Okay, so you folks aren't responsible for the day-to-day operation of the school. It's the superintendent's job. So be aware of that. The superintendent, when we talk about teachers, generally, I talked about tenured and non-tenured. Superintendents don't have tenure, okay? When you have tenure, you get all these protections in terms of being separated and all that. Superintendent doesn't. The only certified staff member who doesn't, and that's why superintendents tend to have 3-year contracts, okay? So if you wondered, why we do that, that's why. Can't do 4, can't do 5. We typically do 3-year contracts, and that's a maximum that's allowed. Superintendent's required to submit a report to you annually. You are required to evaluate the superintendent annually. Again, you don't evaluate people below the rank of superintendent. That's superintendent's job. And the superintendent is generally responsible for hiring staff. Now, you guys have a specific policy on that, so you're a little different in that regard, but generally the superintendents in Connecticut are responsible for hiring everybody below all the non-certified folks. And then for teachers and administrators, the statute gives you a choice. Either you delegate that to the superintendent, or you can reserve some of the responsibility, and that's what you all do. And there's a policy, and again, I encourage you to take a look at that. So on page 6, page 7, top of page 8, I have a chart. And on the left side, you'll see it has board responsibilities, and on the right side, it has the superintendent's responsibilities. I won't go through that point by point now, but I encourage you to take a look at that. It's just examples of what I've already, gone through here. Your role is to establish the policy. Superintendent's role is to enforce the policy, and things of that. So I encourage you to take a look at that when you have a moment. Okay, the board attorney. Again, Bridgeport's a little different. Bridgeport, I believe the charter says that it's the city attorney's office. The attorney's office has the authority to hire legal counsel to help. We are the legal counsel at this point in time. But importantly, to understand, we don't represent the superintendent. We represent the board. We don't represent individual board members. Obviously we'll defend you and through insurance and everything else if you're sued as a member of the board. So that's an important distinction. We work closely with the superintendent day to day, more so than we work with you guys, but we are your lawyers, and we are our professional responsibilities to you as a as a board. I'm one of the primary contacts, but, we have special education lawyers who help with the special education needs. We've got about 40 attorneys, so, there are other folks who get involved as well. And I talked a little bit about the collective bargaining. I'm not going to get too deep into that unless there are any questions. I talked about certified staff, tenured versus non-tenured in that process. And so let me go on and talk a little bit about the Freedom of Information Act, if I can. So the Freedom of Information Act really has two parts. The first part has to do with meetings like this, and it dictates how meetings are run and what happens. And the second part has to do with records. So we start with the broad proposition that you represent the public, you're doing the public's business, public should have the right to see what you're doing. Okay, that's why we have public meetings. And there are exceptions to that. I'm going to talk about some of those exceptions. That's the general rule of thumb. Similarly, the records of the Bridgeport Public Schools and the records of you as board members are considered public records. The theory there is you're doing the public work, the public ought to have a right to see that. Of course, there's all kinds of exceptions for that too. Student records, personnel matters, school safety plans, there are exceptions, but those are the general rules. So you always start with the general rule, and then is there an exception? And the way that exceptions work in this area is it's got to be exactly, it's got to fit exactly. If it doesn't fit exactly, run the risk that somebody's going to be able to file a complaint with the Freedom of Information Commission, and there's a possibility of penalties if we don't follow that, okay? So generally speaking, there are regular meetings. You guys are familiar with that. There are special meetings. A special meeting is basically a meeting that's not noticed at the beginning of the year as a regular meeting. And some of the key distinctions are, if you're at a regular meeting, you can add to the agenda, okay? You need a 2/3 vote to add something to the agenda, and you can do that. But at a special meeting, not add anything to the agenda. They only address exactly what's on the agenda. Now, I want to talk about executive session for a moment. I mentioned the general rule of thumb that you're supposed to do the public's work in public, right? The Freedom of Information Act has identified certain things that are so important that you ought to be able to talk about them in private, and it has given you the right to do that. So what I would say about that is take advantage of it, okay? Now, it's your call. If there's a subject that could go into executive session, but you think it's important that the public see and hear, that is fine. But understand that exception is there. There's been a public policy decision by the legislature that said, you guys ought to be able to talk about some things in private. And that's one of those things. So let me talk to you about what some of the things that you can talk about in executive session. So the first is the appointment, employment, performance, or dismissal of a public officer or employee. Okay, so you have the right to be able to talk about personnel matters in executive session, and generally most boards will do that to protect the privacy of the individual and also to be able to have some candid conversations sometimes. Okay. The next one is strategy and negotiation with respect to pending claims and pending litigation. Somebody suing you, or even if there's a complaint with a public agency, you ought to be able to talk about those privately because, certainly if you're talking about a settlement strategy, you don't want, the other side to hear it and to figure it out. And also, that's one of those particularly where we talk about litigation, even if it's not in court, it's administrative. If it's out there in a public meeting and there's a tape recording and there's minutes, believe me, in this day and age, go to that information and they will use it against you, right? So if you're dealing with a particular hot topic, even if the board's consensus is we didn't do anything wrong or, this is how we view it, but one person, I told you that you only, as a single individual, you don't have any individual authority, you only act as a board. But trust me, if one of you says, I think we violated the law the way we treated that employee, that's going to come out in the trial. And trust me, no matter what we argue and say, the juror is going to say, well, if that board member thought that, it's going to bite us in the rear end. And so therefore, that's another reason why these things tend to be discussed privately. I mentioned security issues. You're allowed to talk about them privately. You're allowed to talk about matters that would result in the disclosure of records that are protected. Okay, so if there's a confidential document, you want to talk about it, you can talk about that in executive session. And so the way that sometimes can work, just to give you an example, let's say you needed a legal opinion from us or the city attorney's office on an issue. Okay, we give you the written opinion, and now you want to talk to us about it. We can use that to go into executive session to talk about that document. You just can't say, Dugas, come into a meeting, we're going to go into executive session, we want your opinion on something. There actually has to be a written opinion, and then we can discuss that in executive session. There are some other exceptions, many of which would never apply to you guys. Certain aspects of, let's see, that's for purposes of executive session. Those are really primary things you can go into executive session for. Now, a couple rules about executive session. First of all, if you go into executive session, you need to say the reason. It's got to be one of those reasons I mentioned, a personnel matter, discuss pending litigation, security matter. And then you've also got to state who you're inviting into the executive session, okay? To executive session to discuss a personnel matter. We're going to invite the individual. And we're also going to invite the board attorney to come in and talk about that. Okay. No minutes in executive session. And very, very importantly, what happens in an executive session stays in executive session. It shouldn't be told to the Post reporter what happened. In part because, again, the law said this is special. You ought to be able to talk about it, right? That's one reason. The other reason is when you do that, you compromise the trust of your fellow board members. And then the other reason is you've just turned it into an illegal meeting because it's supposed to stay in there. And so there's a possibility of a complaint, fines, and the like. So let me also talk about, just go back a minute and talk about what a meeting is. So I'm going to read you the definition of what a meeting is. It says any hearing or proceeding. Now, those are kind of formal, right? So if, for example, we're dealing with teacher termination, thank you so much. That would be a formal hearing or proceeding, or at a grievance hearing, which we can do. I'll talk about that in a moment. That's a meeting and we got to comply with all the laws. There's also, if there's a convening of a quorum of you guys, and you're talking about something over which you have jurisdiction and authority. If it's a quorum, you need to comply with the law. So as usual, there are exceptions, but if there's 7 of you, right, on the board, or 9, I forget what you. Anyway, if a quorum of the board got together and started talking about the budget, started talking about policy or any other topic, that would be a meeting, and that would need to be in public, and you'd need to post a notice, okay? Now, there's an exception for a political caucus. So if all the Dems or all the Republicans or whatever it is decide to get together, you can do that privately. That's okay to talk about an issue. What you can't do is bring in somebody from the town committee or the mayor or even a lawyer. It just has to, or even the superintendent. It's just got to be board members of that particular party, and then you can do that privately.
That's a caucus.
Pardon me?
That's a caucus?
Yes, ma'am.
Okay.
Now, this one's going to drive you nuts if you're not familiar with it, but there's also something called a non-meeting, okay? And really what it is in the statute, they say the following things won't constitute a meeting for FOIA, so you don't have to follow any of this stuff, okay? And one of them is strategy with respect to collective bargaining. So if we're negotiating the teacher contract, and we want to come to you, or even if, we have a tentative agreement and we want to come back and talk to you, we could just meet. Now, a lot of times what'll happen is that'll be just before a board meeting or just after, sometimes even a recess. But that's one reason we can do it. Another reason we can do it is if we're talking about hiring a high-level person. When you hire the superintendent of schools, you appoint yourself as a search committee. And once you've done that, then you don't have to do it in public, right? Makes sense. You're hiring a pretty senior level person. I'd say, principal on up, that certainly would qualify. So, that's another thing. I just want to point out in case you hear that, or you wonder why it is we're meeting and we're talking about collective bargaining and we don't have to do it, in conformance with the law. Also, the statute was amended to basically talk about electronic meetings, okay? And so I'm not talking about a hybrid meeting. What I'm talking about is you guys are all chatting about something in email, okay? If it's a quorum of you, that's an illegal meeting. And the way this often happens is when you guys will send an email and somebody responds to it and hits reply all, right? And now you're going back and forth. If it's a quorum of you, you've just held an illegal meeting, okay? And if somebody gets wind of it, gets reported, it's a complaint, it's a problem. Less than a quorum of you can do that. Of course, a caucus can do that. And if it has nothing to do with what you have responsibility over, then that's okay. It can be a quorum. So for example, you decided to get together at a restaurant for a holiday celebration. You don't have, that's not your business. You could do that. Also, if it's just an organizational kind of thing, who's available to meet December 20th to get bored by the attorney for over an hour about laws? Let us know your availability. That's okay. But it's just when you're dealing with board business that you can potentially run into problems. I won't get into the whole public records thing, except because really that tends to get funneled through the superintendent's office, and I think here in Bridgeport, actually the city attorney's office. But I do want to point something out, which is whether it's a memo, whether it is an email, whether it is a text message on your private phone, if it has to do with Bridgeport Public Schools business, that is a public record. And somebody can ask you to do it. So if there's a controversy on a particular subject and you're going back and forth, understand you better be prepared. I always say to folks, before you hit send, do I want to read this in the Post tomorrow? Because if the answer is no, then you ought not to be doing that. So just understand, it's not illegal. I mean, if it's less than a quorum, it's not illegal, but somebody can make a Freedom of Information Act request, and they can get that information. And number one, now somebody's in your personal cell phone, not literally, but they could ask you to dump it. you know, you got to be careful about what you say because it can be embarrassing, and lots of people have been embarrassed when something came out in the press that they've said. So mindful of that. Okay. Give me a second. There are record retention rules. I refer to that in here. Oh, let me just talk about evaluations for a moment. General rule, things that are in personnel files are in fact public records, okay? If I got disciplined, that's a public record. There may be things in a personnel file that aren't public. I've got a medical situation, right? And what it says is if it gets to the level where it's really not a matter of public concern, then that's something that doesn't have to get disclosed. Now, there is an exception for teachers, and that has to do with evaluations. Teacher evaluations are exempt from the Freedom of Information Act. They're exempt from disclosure. You can't get them. I can't get them. A member of the public can't get them. They're protected. Now, obviously, the superintendent and supervisors in the need to know obviously can look at that stuff. Even as board attorneys, if we're going through a discipline situation, we're entitled to have access, but you can't. You can get access, and the public can get access to non-teachers, non-administrator evaluations, but the same rule applies to administrators as teachers, everybody except the superintendent, all other certified staff, their evaluations are protected. Just see if there's something else. In the materials, I also talk about record retention rules. So if anybody's ever interested in that, I have those materials. You know, most importantly, with the Freedom of Information Act, if there's any takeaway I want you to have, it's when we're talking among a quorum in email, text messages. If it's more than a quorum, if it's a quorum or more, it's an illegal meeting. Even if it's not, understand that there's disclosable. Use your executive session topics, right to use them, and you should take advantage of them, but make sure what happens in the executive sessions stay in the executive sessions. So my voice is running out, and I did want to leave a little time for Q&A. Stop there, and I'm happy to answer any questions you may have.
All right, board members, just remember, I want to go one board member at a time. The mics are set up a little bit differently, so if you have your hands up, I'll recognize you. I have to grant you access to speak. All right, well, I'll start off with a question. I have a question regarding meetings. So I looked at the statute 1-200 at the definitions of a meeting, and I just wanted to make sure I had it clear. Meeting does not include any meeting of a personnel search committee for executive level employment candidates. And I think you hit it. Of course, that counts for the superintendent. But I wanted to just be clear on the record. Does that apply to deputy, assistant superintendent, the cabinet? And then I think you mentioned something about principals. And what's the executive level?
The short answer is yes. There's no clear definition of what an executive level position is, but there's certainly been FOIA decisions involving principals, and they said, yeah, that's a pretty important position. Of course, you guys have a hiring policy. You know, I'd have to think about if that required some meetings as part of that, so that would take it out of that exception. But under the Freedom of Information Act, yeah, all those folks, you could do those privately without having to have a public meeting and follow the act.
Okay.
So what we've been doing in the Personnel and Contracts Committee is offering the candidates the option of executive session, and they've been declining, and we've been holding it in public session.
Yeah, that could be done that way for a personnel, under personnel for that person. The problem with that is if you go into executive session, you have to identify who the individual is. And some people don't want their name known. You know, they may be working in another district. If you did that, then, you know, the better approach is to appoint yourselves as a search committee, and that way you can do it privately.
I see what you're saying, yeah.
Quick point of information, clarification, as far as interviewing somebody in a hiring process, they got the right to request executive session and demand to be in public executive session, correct?
Yeah, actually, executive session is your decision, right? So the presumption is it's in public. If there's something you want to handle, let's say a personnel matter, that's your call. You could say, well, we're going to do it in public. But if you go into executive session, then the employee, number one, you need to notify this ahead of time. You're going to go into executive session. Their only right is to insist it be in public. They don't even have a right to insist that they can be in executive session. You could talk about them in executive session, and if they don't ask for it to be in public, then they don't have a right. I mean, you know, usually you will give somebody that opportunity. It's a matter of fairness.
All right, thank you. Mr. Traber, was Mr. Traber finished with his questions?
Yeah,
Okay, so I guess I'm on.
I just was following up on that. I have another question later, but.
All right. Any questions online?
I had some questions.
Continue, Mr. Sakalovic.
All right, now the FOIA meeting room. There's been some updates. We got a meeting must be noticed. I don't know, have you seen the book with the update? I would like to verify it's.
I have not read the book.
So I'll just read it out. That there's extra responsibilities. We have 24-hour notice for posting of the agenda. And this is a recent topic.
This is a special meeting, Joe?
Special or regular. It's been updated in the new statute to include regular, to have a posting on the board's website, a special additive to and it's specific to the board's website rather than posted online.
Yes.
So posting on the board website has to be the board webpage, not something like Parent Square or like one of the schools. It has to be on the district website within 24 hours to be in a duly called meeting and not to have the possibility to have our decisions overturned in
Correct.
FOIA.
You're correct.
So it's best that we actually adhere to this policy. Okay, now let's a little bit about executive sessions. This is another topic that came up. Goals and objectives. Does that qualify for executive session?
I'm sorry, say that again.
Goals and objectives for the superintendent district.
My ears are a little clogged, so I'm having trouble.
Excuse me. Goals and objectives
Oh, goals and objectives.
for the superintendent in the district. Does that qualify for executive session?
Yes.
Thank you. And what else? Okay, and a caucus. Now we've got, when you're determining party, we've got people that have been elected third party or are actually registered in one party, but were elected under another party.
Oh, boy. Okay.
How does that work? Would somebody elected under independent party be considered a Democrat if they're a registered Democrat, or?
I would say solely for purposes of the Freedom of Information Act and caucus, it's going to come down to what your party affiliation is at that time.
Okay, thank you.
Okay, I know the rules are a little different in terms of minority representation, and that gets kind of complicated, but for FOIA, it's whatever you're registered at that time.
And finally, with the budget, the superintendent prepares the budget, we approve the budget, but we as a board, if we want to make changes to the budget, we can do so by a 5-4 vote on most any item.
You mean after the budget?
After the budget is presented to us, say if they want to, just for an example, achieve savings by laying off 7 psychologists and a board member would propose let's get rid of a couple of jobs that weren't here before. We've got the right to do that.
You certainly have, if it's broken down as that kind of a line item, you certainly have, ultimately you adopt the budget, right? So as long as it's broken down by, in that particular way, you can change that particular line item.
Thank you. That's all I have.
Ms. Bain?
Yes, okay. I just want to be clear on notices, right? Because one of the things I couldn't really, I'm sorry, thank you. Thank you, I'm sorry. I just want to be clear on notices for Freedom of Information Act. You says meetings operating in a fishbowl, everyone can see. Regular meeting, we can add to the agenda during the meeting.
Yes.
Right? And how soon, for a regular meeting, does it also have to be posted 24 hours?
Yes.
Before, because it's not here, it's not noted here. 24 hours before?
Yeah, although some communities in their charter have a greater requirement. I can't remember if you guys have a greater requirement here. Sometimes it's 48.
Ours, I don't believe ours is greater.
Wait, acknowledge you.
Sorry.
Go ahead, you can.
Okay, you have the floor.
I don't believe ours is greater insofar as it includes weekends. The state law doesn't.
So ours is 72 hours include. So I think it's consistent with the laws.
Okay, I'd have to look at that. I can't remember off the top of my head.
All right,
Ms. Bain, we
Yes,
can
thank
continue.
you need to, yeah, okay, and, so I'm new, right? So I'm learning, and I just want to make sure I'm going down the right road here, and as far as meeting caucuses and quorums. A quorum consists of 4 or 5?
You're 9 members, so a quorum would be 5, correct?
5, okay, 9 would be 5, okay. And we can have a quorum meeting, but it has to be filed, the minutes have to be filed, and it has to be a notice for the quorum? I just want to make sure that
Minutes are different.
okay,
The minutes,
yeah,
you just have to have those, I think it's 7 days under the statute. You have to have them posted 7 days, but that has nothing to do with the quorum.
okay,
Okay, when you start the meeting, you've got to have, at least five people, and then it's majority, the vote is,
considered a public meeting,
yes,
okay. And the meeting have to be noticed, you have to have notice of the meeting because it's considered a public meeting.
correct.
Okay.
Now, if it's not your regular meeting, then it's a special meeting, and you'd have to notice it as a special meeting.
Okay, great. And the caucus is a private meeting amongst less than 5,
Well, it could be more, no, it can be
as many,
9 if you were all from the same party. You could,
same parties for
it's just
political.
got to be the same party.
Okay. Can't all be from the same party? Okay, so we have to be from the same Democratic or political party?
Correct.
Okay, great. Just wanted to make sure. I just wanted to clear that up for me. Thank you.
Yeah, you're welcome.
Casimir, you have any questions?
Yes, so really quickly, I just want this broken down again about meeting notice. I know that I don't mean to beat you over the head with this, but I just want to be clear that if there's a board meeting that starts at 6:30 on a Monday, when is the latest that meeting needs to be posted, whether it's on Parent Square, whether it's giving notice to the, what's the lady here? That we have, the city clerk, or just in public period? I'm just trying to, because this keeps bothering me, like what happened with the last meeting.
Friday,
So it has to be by 6:29 on the Friday before.
yes.
So it can't be 6:45 on the Friday before.
No, it would, no, yeah.
All right, so when we talk about how many days notice, this means business days.
Yes.
Correct? Not regular days. Okay, thank you. One more question I have is about the chain of command. You had said the teacher, then the principal, and then the superintendent. But I thought it was teacher, principal, building administrator, and then superintendent.
Yeah, whatever positions you have, yes.
Okay.
Director, whatever other positions you guys have.
I just want to make sure I had that clear. And something else that I had a question about was 2/3 vote. Something needs to pass by a 2/3 vote. So if there are 9 members here, and forgive me, I didn't get very good grades in math, but if there are 9 members here, how many members constitute 2/3 vote?
Well, 6 members.
It would be 6. So how do I calculate that? Let's say if there are not 9 members, there are 7 members, there are 5, 4. Do I go in my calculator and do 0.66
Yep.
times whatever the amount of people that are there?
Round it up to the nearest body.
Yes. I'm happy. That's all I had.
Okay.
Thank you.
Mr. Woodson,
No questions for me.
Mr. Medina,
He has his hand.
Yes. Can I be heard right now or no?
Yes.
yes.
Thank you very much. I'm just going to piggyback a little bit on what Ms. Casimir questioned about the meeting, a Monday meeting that was formed for 6:30 p.m. and was not posted by the 6:30 deadline, but was posted after that time. Let's just for sake of argument, 6:55. It was then posted. But then the meeting is held after that 6:55 time. Is that a legal meeting?
I would say no, because
You posted the meeting for 6:30, regardless of what time you started.
Thank you. When it comes to budget, I know this meeting was going kind of fast for me as a new member, and I'm learning a lot of things. But when it comes to budget, and the budget has already been approved, and I'm trying to get my hands on it as we speak, and we're talking about the superintendent as the head of the superintendent office and her being our employee and us being the only boss and things like that. In that office, or I think somebody mentioned the name cabinet, her staff, those staff members are being paid under the budget of the Board of Education, correct?
yeah.
So are those new possible new employees or new hires or promoted people, does those employees or new hires or new position need to be approved by the board, by the body?
Yes, but not because of the budget. That's because you guys have a very specific rule on hiring, just like you have a specific rule on contracts. So yeah, you've got to follow your policy on hiring. I forget the number, but I'm sure you guys you're familiar with it. Somebody could point you to it if necessary.
Please, I would love that either now or later at a later time, because I would like to know, because if we're in charge of the budget, according to the words that you use, that it all falls on the board to be responsible for the budget. How can we control the budget, make sure that we don't go over our budget when staff, positions are being, new jobs and new positions are being created, or let's say promotions or whatever it might be, that is going to be working within our budget. And I don't know if that office or that cabinet, do we have, and maybe the chair or anybody else can answer, do we have a budget for that cabinet to make sure that, maybe the superintendent needs to be informed that this is our budget for this office staff, for this cabinet?
I'm not that familiar with your budget, but, generally it doesn't get down to names. There's categories and, certainly that's a legitimate question to ask. Let's say there was a new position being added. You certainly had every right to ask the superintendent when the position comes before you is this budgeted? And if not, is there money in an empty account that, would cover it? But that would be the time to ask that question.
Okay. I don't know what time that will be for me because I'm learning about this process to find out how can we get those informations and probably through committees, I guess, as far as contracts, because I am concerned because if we're held responsible or AKA liable, that, to make sure that we control the budget the right way and not have, no knowledge of anything that is being done or anything that's going to be added to that, cabinet or that office staff.
Right, totally legitimate question for you to ask. And that would come up in the committee or when it came to the board for approval.
Thank you. And also our bylaws. What statute or standard or law do we have to mandate to make sure that our bylaws are posted on our website? So I've been asked a few times, and I'm new to this, like I said, and they said that things have been done before, but there's an old one, I guess, somewhere, but people are trying to find out what are the new bylaws, and I can't tell them anything because I don't know. So when do those bylaws that have been approved have to be posted according to FOIA?
FOIA doesn't address that at all.
Okay.
It's good practice. Everybody I'm aware of, almost everybody I'm aware of has their bylaws, policies, including bylaws on the website, but it's not in any statute anywhere.
Okay. I'll surrender the mic. Thank you very much. I definitely want to learn more and meet, but thank you.
Mr. Benahan?
No question at this moment, Madam Chair. Thank you.
No. Also, I'll mark you present when I called your name during roll call. I didn't get a response. All right, Ms. Bain?
Okay. I have a question about policy. I think you need to. Okay, I have a question about policy. You, board function and roles, right? You said, we set goals based upon the needs and aspiration of the community. And you also said we formulate policies. There's policies that's already in place. That also allows us to amend.
Absolutely.
Policies, right? Okay, great. Just wanted to get that clear. And we evaluate the performance and results related of the superintendent according to those policies?
Well, that could be part of it, but certainly it is how are we doing, right?
As a people.
Yeah.
Board.
Yeah, we set some goals, and it could be student achievement, for example. Mm-hmm. We set goals. We've now got a policy, and how is that working? Mm-hmm. The answer, we're not meeting our goals, and well, then you reevaluate the policy.
Okay, great. There's also something else, but I can't really remember right now. All right, thank you.
Welcome.
I have a few questions, Mr. Dugas. Just to clarify some past practices of the board, to qualify for executive session, we don't need an asterisk on our actual agenda item saying an item may qualify for executive session.
No, especially if it's at a regular meeting, you could just, if there's a topic, somebody could motion without an asterisk and say, we want to go into executive session on that topic. If 2/3 of you say, yeah, then you can go in. You don't need to have an asterisk necessarily.
And I want to clarify for the 2/3 present. So if we have a board meeting, 6 members are present, or 7 members are present, one leaves to use the restroom and the vote comes up, it's present at the time of the vote.
It is.
Okay, thank you.
Of course, she was going to make me do the math. I was going to get.
Well, no, because it is 7, you take away 1, 2/3.
It'd be 5, but yeah.
We're not getting into math right now.
I'm good, thanks. Appreciate it.
I have a question, and the first terminology for it that comes to mind is good governance of the board. So it would sound like if we have a law or procedure that hasn't been followed in the past, how do you suggest we deal with that? So if I'll give an example, in our bylaws, it calls for us to have a quarterly meeting with the public with the status of the schools. And I know in the 2 years I've been on the board, I don't recall a community forum pursuant to our bylaws, although we are required to do so in our bylaws. So when we, not trying to sound like, when we don't follow, I was going to use breach, but when we don't necessarily follow our bylaws, what is your advice as to that? Because
Yeah, well, I mean, obviously you should follow your bylaws. If you should have a discussion about that, if it's not needed, then you can amend the bylaws to take it out. If it's your wisdom that, yeah, that makes good sense, why aren't we doing it? Then go ahead and do it.
Then I have, this sounds like a silly question, but is there any kind of action an individual board member could take if the board doesn't follow its bylaws?
The only thing I can think of is somebody could file a mandamus action, which is a lawsuit. I mean, you want to spend your money on that? I would think there are more efficient means of getting things done, but that would be the only legal avenue that I could think of, and I think you'd have standing to bring the suit. Hopefully it would never come to that.
I have another hypothetical for you. How would you deal with if there was an allegation or statement by a board member that they would testify against the board, whether it's in a legal action or in a FOIA action? Is that a conflict of interest?
Yeah, I mean, I would hope that would not happen, regardless of, I mean, obviously, if somebody is subpoenaed in a lawsuit, we all have to tell the truth, right? You don't want to perjure, and you tell the truth. On the other hand, again, I can't caution folks enough to, you need to do what's in the best interest of the Bridgeport Public Schools and the children, and you need to think about what you're going to say and how that could negatively impact it.
Thank you. I'm going to go around again.
I have a question.
I'll acknowledge Superintendent Dr. Levy-David.
Good evening, Mr. Dugas.
Good evening.
Good evening. Could you very quickly for me provide us with a definition of what a hostile work environment constitutes? What does that look like under the law?
Generally speaking, when we talk about a hostile work environment, it has to be based on what's known as a protected class. Race, age, gender, sexual preference, those things where there are laws that protect it. That's in the eyes of the law. Sometimes.
I'm sorry, point of order. This doesn't seem to fit the agenda. This board roles and responsibilities, this seems kind of off topic.
I'm going to overrule that. you can continue with addressing the question.
Now, school districts sometimes have policies that talk about it in a broader sense. So, I can't remember if you have a general, non-discrimination harassment policy that generally talks about that. So that's a possibility, but usually we're talking about a protected class.
Thank you, Mr. Diggers. And my second question, I would like it if you could please, because I see this under CGS 7-465, where it says no indemnification for slander, defamation. Could you provide us with a definition?
Excuse me.
Slander and defamation.
Well, defamation is the broad category. There are two types. There is slander, which is a spoken defamation, and there's libel, which is written. And it's generally an untrue statement about somebody that causes a harm. It's kind of a complicated area, old law area of the law. But, generally you have to make a statement that you know to be untrue that is harmful to somebody. Now, a lot of nuances, but opinions are not actionable. So if you say, it's my opinion, but you're not a good lawyer, that's not actionable, right? If you say you lose all your cases, you're terrible because you lose all your cases, that's not true. And so theoretically that could be actionable. But if it's purely an opinion, and particularly if you couch it, then it's not, but it's a messy area. It's one of those things where, we can talk about what the line is, but you shouldn't be anywhere near the line.
Thank you, Mr. Davis. Appreciate it.
You're welcome.
Mr. Traver?
Mr. Dugas,
You talked earlier about the board's need to ensure that its policies were carried out.
and I assume that means we have
The right to ask for data. And one of the things that we need to know, we talked about staff, the hiring and changes in staff. And so that's a reasonable thing for us to know, is if staff resigns or retires or changes positions or is brought on or new positions are created. Would that be correct?
Well, here's what I would say about that. There's the formal answer under the Freedom of Information Act. The formal answer under the Freedom of Information Act, well, let's say that information is available. You could, as an individual, make a Freedom of Information request for that information, right? You would have no greater standing or rights than any member of the public to ask for that. The board could also vote to instruct the administration to provide certain information. So that's the Freedom of Information answer. Certainly in most school districts, there's a more informal process, and if information is not unduly burdensome and relevant to issues over which the board has jurisdiction, normally that information is provided without having to go through those formalities.
Okay. But if the past practice had been to provide that at every staff meeting, at every board meeting, sorry, staff, then that would be something that would not be unusual to see, I guess is what I'm saying.
And I really can't answer that.
I'm trying to get us back to that standard, to try and get an idea of what's going on. There have been some changes, and
just not following what's going on.
I think that's the genesis of what Mr. Medina was asking about. Thank you.
Welcome.
Go down.
Oh, yes, I have something.
Just one time.
There you go. Okay, so, Okay, I'm new. I'm just gonna say that, newly elected. And this is my second meeting. And the first meeting I went to was disturbing for me as a board member. And sometimes in looking at past meetings, board meetings of the district, they were also disturbing. It's one thing to actually see it on video, it's another thing to actually sit in it and to be sorely perplexed by what was going on. I know there's something like a sergeant of arms. Is that something that we can, because sometimes I don't want it to continue in that manner as it went last time, but we need some sort of mediation when it gets to that point. What would you suggest for us to keep on task of the agenda and not go too far into the weeds? I'm asking, I guess I say, would you suggest us to look into or even consider a mediation process like that? That's one thing, that's one question. I'm gonna let you ask that and then I'm gonna touch back on something else.
Yeah, well, certainly,
I think you guys may.
done this in the past, but CABE can provide you free of charge with services that are very helpful in that regard. You know, it's hard to make progress if folks aren't listening to each other and working together. And, you know, this is sort of I'm going beyond the lawyer at this point, but, you know, the other thing I would say is, you know, there are children out there as role models and should be kept in mind. What are you teaching the children of this city? But I'm outside my lane now, but I'm editorializing, but that's what I'll say.
Okay, I'm just gonna keep going down the line.
Wait, I'm not finished. I have one more thing
sorry.
to ask you. In regards to the hiring that my fellow board members are talking about, you said the superintendent's function, right, is the hiring practices of her cabinet, is it not?
It is, but
Again, Bridgeport has
a very specific policy comes to hiring, which is a little different than normal. And, you know, even a little different, well, I guess it's not. Anyway, it's a little different and you need to make sure you follow your policy.
Okay.
And that,
We can amend that.
law, you could say, superintendent, hire anybody you want. That's not what Bridgeport has done historically. I'd be surprised if you departed significantly from that, but you do have a very specific policy and you have to follow it.
Okay, and there are other districts that does not necessarily have the policy we have.
Correct.
That's in the state of Connecticut.
Oh, yeah.
Okay, great. Thank you.
Okay. Just gonna go down the line. Casimir?
No.
Oh, you got it.
Yes. I'm just gonna ask a quick question about bylaws. Like,
Point of privilege, there's no talking when a board member has the floor. I'm hearing too much back and forth, so we're going to be the role models for the children watching, so no talking while Ms. Casimir or any one of us has the floor. Thank you.
So, as far as the bylaws are concerned, in your experience with other districts, when there's an amendment to the bylaw that has been voted on and passed, I won't say should, but I'll just tell you how I feel. I feel uncomfortable about having a Word document that can be adjusted or amended to, and I'm not saying that it's gonna happen or if somebody's unscrupulous, but is there another way that when we have voted on policies, because this is important stuff, that it not be a Word document that one or two people have? I just wanna know, do you know of a better system than that? Because right now, What I feel like is I want to go back to every single meeting to make sure that that the board voted on this, even if it was before me. Before the new bylaws go up on the website. So this is just your expert opinion. Just let me know what you think about that.
You know, if my secretary were here, she'd tell you I am not the most tech savvy guy when it comes to Word and how all that works, but
there is a read-only version
of documents, and I certainly would suggest that you send them out in read-only version and have one person who has the authority to make changes to it, and that way you avoid that, and that would give some comfort, along those lines.
Thank you.
I am going to make a motion that we move into executive session to specifically touch on specific questions regarding our bylaws that we have, since we have counsel here.
If you didn't have executive session on the agenda.
That was the question with whether we needed to have an asterisk as to whether it qualifies for, the special meeting is already.
Point of order.
Well, no, that's actually fine, because there's no executive sessions for special meetings. So good, nothing like good learning. But
only if it were on the agenda.
What I am going to say to board members is that we will, for specific questions as to our governance, we can have a special meeting towards it. As Attorney Dugas mentioned earlier, comments that we say that are recorded can be used against us if any kind of claim is brought against us in the district. And that is not just limited to the post. But if there are concerns, we should be able to discuss it freely in session. And so that way we can be able to proceed business in order and at least clarify some of the questions that have arisen during various transitions. So we'll just keep it focused on to going down the line. So Mr. Woodson.
No questions from me.
Okay, Mr. Sokolovic.
Yes, first I'd like to quickly, through you, Madam Chair, address Ms. Casimir about the bylaws, because you can find it. They were painstakingly reconstructed with the dates as you suggested at the last governance meeting or two back. I could send you a link and you could watch them reconstructed piece by piece, or we could do it at a 2.5, 3 hour meetings all over again. Okay, also now, as you mentioned, to Mr. Traber's request, he's got the right as a citizen to FOIA stuff, correct? Does not a board member also a citizen that also got a right to file a FOIA complaint?
Yeah.
When the board is, because, okay, I'm gonna lay it out. It was a public meeting. There's issues with the timing of the meeting. The meeting was unduly posted. The city attorney was giving us advice, exact opposite of what you were giving.
Mr. Sokolovic, my only concern is that you're waiving attorney-client privilege without taking a vote of the board. And you can't disclose what we've been counseled by counsel.
What happened at a public meeting, discussing what happened, bylaws and policies, which is the subject of this. I want to know if we're on.
No, sorry, I'm going to overrule that. No. You're not waiving attorney-client.
That is waiving attorney-client privilege. I'm not asking for privileged information. I'm asking for information on
privileged information. Mr. Sokolovic, please, 1 second as I explain.
I got you. I take your point. I take your point now. I got it.
That you have to just be mindful of our role on the board because it is a power shared amongst us as a whole.
All right. I won't speak on a lawyer again.
Disclose any information that's protected by the 9 of us as attorney-client privilege in your questions. So you can feel free to move forward, but you don't have the power as an individual to.
All right, I will not break attorney-client privilege. Okay, so we had a meeting on Monday. This is where a lot of these questions were asked. There was a constituent complained at approximately 6:52 p.m. with the screenshot that the meeting was not posted. My initial suggestion was a real easy one. Cancel the meeting, have a special meeting with the same agenda items so we don't risk violating FOIA. I strongly suggested it. I tried it the easy way out of the public spotlight. We had the meeting anyway. When it came time for the action items, I brought a motion. The motion was to adjourn to a time in the future, which is a separate motion from motion to adjourn, which is motion to adjourn is not debatable. Motion to adjourn to a different time is debatable. So that motion was properly seconded. I was speaking, much like I am here, and I was interrupted by the chair saying it's not debatable, not debatable. The chair was not listening. The chair kept speaking over me. The chair took the floor from me. The chair called for a recess. There was a recess. There was some discussion between the chair and some members on the side, a lot of back and forth, reading in a book, trying to figure it out. Came back while my motion was still on the floor. The chair made a motion to adjourn, not the special motion that I made, and it was seconded and voted on. So there was two motions on the floor. Can there be two motions on the floor at the same time?
Under Robert's rules, no.
Okay, so that was a violation, and we couldn't have discussion that the meeting was improperly noticed. And
Mr. Sakalovic, can you stay on the agenda item?
it is on the agenda item. I'm asking about Robert's Rules of Order. That's
We're going
basically in the book.
to,
And again, you're going to try to silence me. And again, you're trying to silence me. I have the floor. I was asking the attorney a proper valid question.
we want to see for our.
Yes, we can, and let's follow the rules. Am I in violation of Robert's Rules or this agenda, Mr. Attorney?
No, let me just say that, with with some of FOIA, it's not always black and white. There's some interpretation. You can call FOIA and get two different opinions on 2 different days. So, I don't know the specifics. I'm happy to look at it and try to get some clarification. But,
And I would like to make a promise to the board right here. As long as we follow rules, regulations, policies, bylaws, Robert's Rules of Order, we will have a calm meeting on my part. But when we're in violation, it's not going to be so calm.
Good to hear.
We're going to move on to Mr. Medina. We're going to move on to.
Thank you. I'm sorry. Yeah, no, I've been with all due respect to everybody, Madam Chair, thank you very much. I just want to have a quick question. First to Madam Chair, because you mentioned something after I spoke, shortly thereafter, about attendance, and I just want to make sure that you have me on the attendance that I was present today.
Yes.
Okay, because you made a comment about it. So on another note, I apologize. I just lost my frame of throat because who is in charge when a hand is raised, especially with me being online at this moment? Who's in charge to note hands being raised? Because I've been having my hand raised for considerable about a time. I've been passed by about 4 or 5 different people. I just want to make sure that I understand the procedures.
Mr. Medina, I call on who has the floor.
Okay.
I tend to go in order of those present and then loop around to those online.
Thank you.
Unfortunately, when we're receiving advice from counsel that's in front of us, my eyes are not on the screen as to who has their hands up. So there is some benefits to just coming in person, but I try, and as well as IT will also kind of wave me down to have me realize that someone has their hands up.
Okay, so you're in charge of that. I just want to make sure I'm making a question because I don't know how it goes. I don't mind if you go down the row. I just want to make sure that I am, notice that I've been having my hand raised past 5 people, so it's hard to think. Mr. Attorney, with all due respect, Dugan, is it correct?
Dugas, yes.
Dugas, I do apologize. Thank you for the correction. When can we talk about that hiring policy? Because it's come up a few times in conversations. When would it be? And you talked about that we have a unique situation when it comes to hiring process that is unique to other areas. As far as, especially when it comes to budgeting, is a big concern of mine, and of course I believe our constituents in our city, to make sure that we can stay on budget and stay things like this. So when we talked about hiring policy, can you elaborate a little bit what you mean by that isn't unique? What is so unique about ours compared to somebody else, if you can give a contrast?
Well, I would, so first of all, we start with the statute, and the statute says basically, you can, as I said before, you can vest the power to hire certified staff exclusively in the superintendent, or you can reserve some or all of that to yourselves. Your policy does that. I don't represent or look at every single school district in the state, but I could tell you that you're in the minority in terms of the level of involvement that the board has in hiring. Now that, I'm not saying that's a good thing or a bad thing. It may be historical to Bridgeport, whatever, but, hopefully that answers the question.
Now, if the board doesn't have not control, but a say or for the administration of the funds, and having for example, we got to talk about the superintendent as a whole, does she have, given her just full reign to hire whoever she deems fit to move the district forward in any kind of capacity and all that stuff, respectfully? There still has to be a line, I believe. So to give somebody in a position of a superintendent free reins to hire whoever, whenever, not giving her, let's say a budget for that office as far as thing. And I don't know if that consists of in our budget, but it just seems wise to be able to say that there needs to be some kind of accountability and transparency when we're hiring or firing or, promoting people, when there's a budget that we have to, constrain it. And I don't know, maybe she can answer herself. I don't know if she's been given a budget for her office. I don't know that. I'm new, but I'm trying to find out because we're hearing things and we want to know to make sure that we stay in line.
So we're probably starting to drift a little bit from the agenda, but I would say to you, I can't imagine that there's not a budget. And if something, again, that's a legitimate question to ask at the time of hiring, whether there's money in the budget. And that would be the time to do it. But I would also encourage you to look at that board policy about hiring, and because I think it's very helpful to understand what the rules are. That's probably the place to start.
Mr. Benahan? If you just came off the mic, but then you put it back on mute. We still can't hear you. I'll come back to you, Mr. Benahan. I'm gonna go to Mr. Traber as he has his hands up and we can hear him.
Well, was I done? I just want to make sure, Madam Chair. Was I done?
I didn't hear anything else from you, so I moved on to Mr. Benahan.
No, when he finished talking, you went and just called Albert, with all due respect. I didn't surrender the floor at all, and I just want to second.
Okay, Mr. Medina. So do you have any more questions?
Respectfully, I'm just gonna pass it over. If I raise my hand, I'll do that at a later time. Thank you.
Mr. Traber, press once. Okay.
Yeah, I want to be clear. I'm hearing two discussions going on here, and I want to distinguish between the two.
Mr. Medina is inquiring.
Correctly, I understand, about what Mr. Dugas describes as an unusual
policy in Bridgeport
of the board having some say over the hiring. And it is a limited say. It gives the personnel committee
an interview
step in the process.
But the superintendent
still retains the final say over who gets hired. We make recommendations to the superintendent based on our interview. She still makes the final decision. And it's a limited number of positions.
and the higher up, as Mr.
Dugas described, the higher administrative positions. So I'm not sure what the full extent of those are.
And that would be worth us learning, because even sitting on the personnel committee, I don't know the full extent. I know we've interviewed assistant principals and principals and
higher level administrators.
So I'm not sure what the full scope is. But it's unusual, and it is purely advisory,
if you will.
But there's also the awareness of what's happening.
And so my questions have to do more with
the movement of positions within the district. Who's being hired for what position, who's leaving what position, whether it's a custodial position, a clerical position, a paraprofessional position, an educator position, or an administrative position. Those changes were routinely part of the board meeting agendas. So that we could just see what was happening within the district. And I know, I believe it was maybe the first email we got from the superintendent on July 31st, were some administrative movement changes that she was making, though.
Just want the record to reflect that Ms. Perez is in the meeting virtually.
Okay. We never received any formal notice as to what those changes were, just that there were changes being made. And it's just wanting to know more about the changes being made that I'm asking about, not whether they're right or wrong, just what they are. I feel in the dark about what they are. And I'm hearing secondhand about things, some of which may very well be rumors, not even real. So that's what I'm addressing.
Sorry, I'm starting to lose my voice here.
We got the cough drops.
Yeah, to your point, the policy is pretty specific. It's advisory. I don't believe it gets down to non-certifieds. Certainly that kind of stuff would be within the purview of the superintendent, subject to the various collective bargaining agreements. In terms of transfers, I don't recall that the policy addresses the issue of transfers. It just requests the issue of hiring. So I would think that would.
Well, that comes up insofar as somebody's applying for a position that we're referring to. So if an administrator is applying for a position that, whether it's lateral or in a raise, in a higher position than they currently are employed in, then they would be interviewed by the personnel committee.
I believe that's what the policy calls for.
But that, again, is purely advisory.
Transferring principals from
to
another, I don't.
Data is more for the overview of the budget and the process of what we do at capacity, not hiring. The two different, that's why I say it's just two different things. One is a hiring and oversight of hiring, not with regard to anything more than that advisory role that you're talking about. The other has to do with the budgetary oversight and what's going on within the bargaining unit, and within the employees, the employment unit of any of the bargaining units and non-bargaining units.
Okay.
Okay. Well, seeing that there's no other hands up at this time, then thank you, Mr. Dugas. I'm sure this won't be the last you hear from us. I'll entertain a motion to adjourn.
I'll second that.
You have to move it.
Oh, I'm sorry.
Okay, I heard a whole bunch.
I moved to, adjourn the meeting.
Okay,
I second it.
all in favor?
Aye.
Aye. The ayes have it. The meeting has adjourned. Have a good night. The time now is 7:58 p.m.
Happy holidays, everyone.
Happy holidays.